Hi, I'm Tina Wang from QueenCityLaw, and today we have a special guest, Grant Elliott, to talk about selling leaky units. Grant, would you like to introduce yourself?
Hi, I've been doing it for about 24 years. Worked for Ray White. Mostly all my career has been Ray White and apartments. So
you have a lot of experience behind you.
Yep.
So what are leaky buildings?
Effectively, it's when a building gets to a point where it needs remedial work done on the property. It also comes into it whether it falls into its 10-year weather tightness guarantee.
Right. And do you think by and large people are more aware of leaky units or leaky buildings?
Yeah, when I first started there was 3,000 apartments. So now we're at over the 30,000 bracket. So it's more common that they go through the remedials.
Right. How common is it to sell and buy leaky units?
Very common. We have a very large database now of just buyers that want to buy that style of property.
Right.
So,
and how often does it get sort of complicated or disputed?
a lot of owners are lost when it comes to finding out what is actually wrong with their building. They don't know how bad it is, so it's something we do have to dig in to find out exactly what's going on.
So I think it's really important that you get proper legal advice and get a really good agent when you sell a unit. So what do you think, Grant, are the important points when selling a leaky unit?
Effectively, my advice to nearly every one of my clients is to auction. I don't really like taking them on without auctioning, mainly because if we get it wrong or they give us the wrong information or it's a lot worse than what it is. Some cases I've seen building that takes 7 years to get fixed. We don't want the buyer to ever try and challenge us back on what we said and what was said and verbally and in writing.
Right. And you'll need to have a really good discussion with the vendor, won't you, about what the state of the unit is. And so
Yeah.
what are some important questions you ask them?
We ask how long ago it came out, the remedials, and whether, because remedials fit into different patterns, whether they're doing a full reclad, earthquake requirements, there could be a lot of different, it could be just drainage on the roof. So we really need to dig down and find out what's wrong.
Right, because you could have sort of isolated repairs on one level and then people get scared and call it a leaky unit, don't they?
Yeah.
So there's different body corporates, more organised ones, not so organised ones.
Yeah.
There's ones that fight internally within the owners.
Yeah.
And then there's ones that are vacant, and then there are ones that are rented, and then there are ones that are rented at discounted prices, right?
Yes.
And so those all impact
Yeah.
the value of the property.
Yeah.
Right. From a legal point of view, we look at whether there was a claim in court, and if so, how far has it gone, who are the defendants, how strong is the claim, and then we look at ordinary levies and special levies because that also makes a difference, doesn't it? So we look at when a unit is on the market that it has leaky issues, we look at whether ordinary levies have been struck and whether they've been paid, because often there's huge outstanding levies out there.
Yeah.
And then we look at special levies and whether they've been struck or expected, and then who's going to pay for what, because somewhere down the line you need to put a line, don't you, to see who's paying what. So all of that needs to go into the agreement, and I think it's really important that the special conditions of the contract cover that. And we've worked with you for some of those, haven't we?
Yeah.
Yeah. So do you have any other comments on those points that vendors need to think about?
It is true, and it's vendors and buyers in both. We've done them where we suddenly find out they owe $100,000 in overdue payments, and then we find out because they haven't paid them, they're not part of the claim. It changes the parameter to everything, really.
Right.
So
because the same unit that is owing levies that the vendor doesn't want to pay, or is likely to get a payout, versus one that's not likely to get a payout or doesn't have levies owing or payable, it's all going to be different,
yes.
Right? Yeah.
Yep.
So I think that also brings into light the pre-contract disclosure statements and how important that is. So there'll be a link to that because there's another video covering the Unit Titles Act disclosure requirements. But basically under the Unit Titles Act, you have the pre-contract disclosure statements and then the pre-settlement disclosure statements. And with the recent changes, you have a lot more information on the pre-contract, don't you?
Yeah.
So what sort of information would you expect to see in the pre-contract disclosure now?
Oh, now we've got 3 years of body corp minutes, but you've got all the committee members' minutes, you've got reports. One we did recently had 49 attachments for downloads.
Yeah.
So now we're starting to download each one of those attachments and file them into one PDF for each version, but it might be 3 years worth of each style. So it still becomes a lot that the buyer can be put off with. It's everything we've got to read because we've got to know it.
Yeah.
So.
Yeah, I think the difficulty is not only you're looking at weather tightness issues, but you could be looking at seismic issues, you could be looking at claims between the owners because they often get into fights, you could be looking at claims with third parties, and there could be different claims with the council and the builder and the roofer, and so it all comes into the mix. And so the pre-contract disclosure is going to be very important. Like you said, it often gets put into a Dropbox link with, sometimes I've seen 100 documents in there, and you're trying to search which one's relevant.
Yeah.
And will the pre-contract disclosure statement have information about the remedial works?
No, usually they don't. And it is very hard when someone asks me what's wrong with the building, because we're not engineers. We can't really answer that too well. The pre-contract will tell a lot, but reading the body corporate committee members' minutes will tell you what they're working through as they go through it. But usually the body corporates don't want to give us any information towards the reclad because they're still going through the court case, and that's all part of the evidence going at the High Court.
Right, because all of that information is supposed to be public, and I guess when they have a claim going through the court, they don't want to put all that information in public. So there is a difficulty, I think, in working out, and that's the degree of risk that purchasers are taking on board. So I think when vendors are selling leaky units, they want out, don't they?
Yeah, they do.
They just want to sell at a loss, and they want out. But I think the difficulty there is that they're often assigning things, aren't they?
Yeah, they're assigning their rights to that court case, or the proceeds from that court case.
Yes, and that's a very important point as well, because people think they're assigning the claim, but that's not what's happening legally. You're dead on. They're assigning the rights to the proceeds of a potential claim payout or a settlement, because you're not sure if it's going to settle, if there's going to be a judgment, but whatever their claim is, they're potentially assigning that to the purchaser as part of the package, aren't they?
Yeah.
But that's also difficult because you don't know if you're going to get something at the end.
Yeah, it does say if any.
Yeah.
So it does become a risk.
Yeah. So, and then the legal issue is that when you're assigning that, the loss of that vendor then changes. So then you have to work with the litigation lawyers to see if there's anything to assign in the first place, and whether that's even doable. But that is another area you need to cover in the agreement, don't you?
Yep.
And I think the cost of that, who's paying for the cost of that agreement, is also a point that you have to put in. Otherwise, that can be disputed. What are the key important things you need to cover off when you meet a prospective vendor client who wants to sell?
Well, effectively, the intention is that they want to sell. If they're part of the litigation, most clients know whether they are or not, but we still need the legal team to confirm that for us, because we can't promote that to a new buyer without that being the case. And so that's where you come into part and double check that all before I get myself in trouble.
Yeah, because it can be complicated, and that's why you often have the real estate agent involved, but also the litigation lawyers, and then the actual vendor lawyers working with the purchaser's lawyers to get this all done, because it is quite tricky, isn't it? So Grant, do you have difficulty explaining to the vendor that the assignment is not about assigning the claim, but assigning the...
No, I briefly touch on that. People ask me for a recommendation on lawyers, I give them two, one being yourself. Usually if they say, who's easier for me to deal with, you're 100 meters away from me, so I can always come down and find out what's going on. But it comes down to that's more their business. So if they think they're part of that litigation, all I want is it confirmed. So.
Right. So I think it's super important that when the vendors sell a leaky unit and they want out, that they can get out, because sometimes the deed of assignment of the rights to proceeds might require them to help the purchaser and assist them in the litigation claim. So that's sometimes not what the vendor wants. And I think it's very important that they also clarify who's going to be responsible for the ordinary levies and the special levies that are coming up.
Yeah.
So Grant, have you seen any vendor clients who have been assisted by maybe agents or lawyers who aren't well adversed in the space, and perhaps haven't got the best advice?
That's one thing. Another agent and I were talking about earlier on. It costs no more to use someone that actually is experienced in doing it. I know of another person that listed one in the city, another agency, and they ran an auction with a zero reserve auction. So first bid buys it, and they didn't get one bid. So in the end, they sold it for $10,000.
Wow.
So I could have rung someone in about 5 minutes and got that.
Right.
I could have doubled it in about 10 minutes. So
because there are purchasers that are wanting to buy.
it's dealing with a certain clientele, and over 24 years of you find out who will buy it, who won't. New first-time buyers won't, and if they do, they just become a nightmare for us because they're always ringing us saying you didn't tell us this. And it's easier to deal with someone that they look at it as a gamble. It could be good, it could be bad, but if they buy enough of them, in the end, it works for them.
And most of them are cashed up, aren't they? Because they can't get finance to buy a leaky building. Yeah. So as discussed today, I think it's super important to get a fully disclosed leaky unit with a well-versed agent who knows what they're doing to be able to tap into the right market to sell to the right type of person. You need a good agent and a lawyer to then work with you to make sure that all the disclosures and the legal requirements are done right, that the deed is done right, and that you won't be responsible for further special levies. Because I have seen cases where clients have come to us with maybe a not so experienced or knowledgeable agent who didn't put in the special clauses in, so they got stuck with further special levies that they didn't think that they would get stuck with. So it's the worst kind of case, I think, when you sell at a loss, thinking that you're going to get rid of it, but then you have to pay more levies to get rid of it. So that's obviously not something that you want. So I think it's important that you are alive to those issues and that your advisors are alive to those issues.
And sometimes also with the special levies, I just got a client at the moment that's asking, they've paid out $30,000 in mainly being for the legal cost to sue the different parties. They're wondering whether that $30,000 was wasted now that they're finally just going to sell it. Because it could be another 5-10 years of their life before the building's finished. And their decision is not to go through the building stage. So should they have sold it earlier? Maybe. But the $30,000 is not wasted because at least they have the rights to the litigation, whatever the proceeds, to be able to offer the new buyer.
But there's no guarantee, if any, right?
But that becomes the new buyer's risk. So
I think it's definitely a lot to think about because, like you said, you could end up paying special levies and people think they're paying special levies to fix the building, but actually it's all of it going into legal fees fighting, isn't it? That's just some of the things that you need to consider when selling a leaky unit. So be careful, be wary, and have the right advisors on board. So please feel free to contact the team, Grant's team at Ray White and my team at QueenCityLaw. Thank you.
Thank you.